Good afternoon again, ladies and gentlemen. Thank you for being here. We're almost at the end. As we discussed earlier, I have to prove beyond a reasonable doubt that the crime happened, but I don't have to present I don't have to present 5 boxes of evidence or 10 boxes of evidence. I just have to present enough evidence that allows you to believe beyond a reasonable doubt that defendant assaulted his wife and the mother of his child on February 12th, 2023. In this case, you heard Ms. Calloway testify about the events of that day. You heard testimony that there was an argument regarding an issue with a sub pump or a U-Haul at 2:45 in the morning. Ms. Calloway testified that when she went upstairs to ask the defendant about the sub pump, whether or not she was justified in going up there at 2:45 in the morning to argue about a sub pump or a U-Haul, I submit to you, is irrelevant in this case, because even if she goes up there, even if she wakes him up, even if she's blowing an air horn in his face, shaking maracas, playing loud rock music, that does not justify the defendant grabbing her hand, which he did testify that he grabbed her hand. And as Ms. Calloway testified, the defendant pushed her down, got on top of her, and punched her 3 to 4 times in the face. In this case, we have more than just Ms. Calloway's testimony, right? We have the picture of her swollen left eye that supports that she was assaulted by defendant, that she was punched in the face. We also have the 911 call that is consistent with her testimony. And in the 911 call, she sounds upset. She sounds like she was crying. I submit to you that she sounds afraid. I submit that her demeanor during the 911 call, her crying, the fact that she's upset, is consistent with someone who has just been assaulted. And that's also supported again by the picture of her left eye. In this case, we've talked a lot about witness credibility. And as we discussed, you're allowed to believe all, some, or none of a witness's testimony. So you can believe that she was assaulted, even if she was lying about the reason she went up there. Maybe she went up there for another reason. Maybe it wasn't about the sub pump, and maybe she was screaming at him and yelling at him and calling him names or something for not fixing the sub pump. That still doesn't justify him grabbing her hand, throwing her down, and punching her 3 to 4 times in the face, giving her a swollen eye. Now, the defendant keeps arguing that due to his size, due to the fact that he's not a trained boxer, but he is trained in boxing, if he had punched her 3 to 4 times in the face, she would have more injury. She wouldn't be getting up. She doesn't have to meet like a minimal injury threshold for a defendant to be guilty. She doesn't have to have, say, a broken face for you to find him guilty. There's no minimum injury, and the judge is going to instruct you that actually, in order to find someone guilty of an assault, you don't have to find that there was any injury. And I also want to briefly bring your attention to defendant's testimony. Defendant testified that he grabbed her hands. Defendant never explained how her eye got swollen. And When Miss Calloway entered the bedroom, defendant had his phone in his hand. He is trained in boxing. He indicates that he has testified that, if he really hit her, she wouldn't be getting up. So he seems to believe he's stronger than her. If she had put her hands on his back, I would argue that his actions of punching her 3 to 4 times in the face, giving her a swollen eye, were still excessive. That's still not justified by her placing her hands on his back. He says that he had to use physical force because she was blocking the door. He had his phone right in his hand. He testified he was just playing chess on it. Why couldn't he use his phone to call 911? Did he really believe that he was in enough danger that he had to use physical force against the complainant? All in all, I believe that based on Ms. Calloway's testimony, we also had the police officer testify as to the complaining witness's demeanor when he arrived. I submit to you that her demeanor of being upset is consistent with someone who has just been the victim, who has just been punched in the face 3 or 4 times by their spouse. I believe that when you go back there, when you look at all the evidence taken together, when you look at her testimony, her demeanor while she was testifying, the picture of her swollen eye, and the 911 call, you will find that based on the totality of the circumstances, defendant is guilty of domestic violence beyond a reasonable doubt. Thank you.
Mr. Kaplan.
Good afternoon again. And again, thank you guys for being here, doing your civic duty. I'm going to say it one more time, and it's my last time. I'm going to say it before I'm sure the judge instructs you on it, that the people have to prove this case beyond a reasonable doubt, without a shadow of a doubt. And I don't believe they can. So let's go into some of the evidence that we saw. First and foremost, we had the officer testify that upon seeing my client, he was calm, cool, and collected, he said. You heard the 911 call. He said, my client, right after the incident, said he was provoked, she attacked him, and he had to defend himself to get out of the room. Same thing he said here today, calm, cool, and collected. Now, we heard the 911 call from the complaining witness. We heard her crying, and then all of a sudden we heard her get angry and start screaming at him. I would say she was angry when this all started. She was upset when this all started, and it continued to be upset when she called the police. She'd been using this, she wanted to use this against my client. Now, the people have said, she could have walked in there with an air horn, maracas, played rock, got in his face. She could have touched his back, and that judge wouldn't justify hitting her in the face 3 or 4 times. We concur. We concur that nothing would justify a 350-pound man hitting any woman or any human being in the face 3 or 4 times. That's not just a non-assault of domestic violence for which he's charged. That could create real harm, real murder, real death, real injury. But he didn't do that. He used the force necessary to get out of that room. Not once, but twice. There's no rule that says if you have your phone, you got to call 911 in the middle of an attack. And if you try to find a different way out of there, then it's not justified. There's no rule to that. Sure, he had a phone. He wanted to get out of the room. He was getting attacked. And it started, mind you, with her touching him. Unjustified, unrequested, touching him, pushing him in his back. And when he moved her, and she continued, and she pointed her finger, she was angry. He wanted a divorce. He didn't want to go to Menards. Let's also remember how this started. She walked up into the bedroom he sleeps at 2:45 in the morning to pick a fight while their daughter was just waking up watching cartoons. Ladies and gentlemen, there is more reasonable doubt here than I need. The bottom line is that my client never hit her. He never struck her. He did what was reasonably necessary to get out of that room when she attacked him the first time and then blocked the door to prevent him from leaving because she wanted that fight. She wanted to hash it out right then and there. She wanted that fight. She picked that fight. And my client just did what he could to get out of there. Yes, she had swelling on the left side of her face. We can't tell you exactly how it happened. But that's how these things happen in a moment. He didn't punch her. He didn't lay on the ground. He didn't put her on the ground and punch her 4 times with 350 pounds worth of force. Somehow, some way, when she fell, she got bruised on the left side of her face. But that is not him hitting her. This was my client trying to get out of that room and away from the situation that she wouldn't let him. My client is innocent. I'm asking at this end of the day that you find my client not guilty of this crime.
Mr. Rich.
Thank you, Judge. The thing that I want you to focus, one thing that I want you to focus on during your deliberation is the picture of the swelling on the left side of her face that supports Ms. Calloway's testimony that she was punched 3 to 4 times in the face. I don't believe that, I submit to you that she did not get that injury by falling. I submit to you that she got that injury when defendant punched her in the face. Again, as we briefly discussed earlier, there's no minimum amount of boxes that I have to present to you. If you believe her testimony, if you believe that the photo is authentic, you believe the 911 call is authentic, if you believe that it all comes together to support her testimony that defendant hit her in the face or otherwise assaulted her, you can find him guilty beyond a reasonable doubt. And I think that, again, based on the totality of the circumstances here, her testimony, the photo, and the 911 call, it supports her credibility in the fact that she was assaulted. So I believe that you will go back there, and when you weigh everything and look at the totality of the circumstances, you'll find the defendant guilty.
Thank you both. All right, folks, we're back to final instructions. Page 1. Heading is presumption of innocence, burden of proof, and reasonable doubt. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt, growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Page 2, evidence. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it's important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments and any commentaries are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things that the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witness are not evidence. You should consider these questions only as they give meaning to the witness's answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I may have excluded evidence that was offered or stricken testimony that was heard. Do not consider these things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based, your decision should be based on all the evidence regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. Page 3. As I said before, it's your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness' disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There are no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does a witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Had there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The defendant is charged with the crime of domestic assault. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant assaulted Krista Noel Calloway. A battery is a forceful, violent, or offensive touching of a person or something closely connected with her. The touching must have been intended by the defendant, that is, not accidental, and it must have been against Krista Noel Calloway's will. An assault is an attempt to commit a battery or an act that would cause a reasonable person to fear or apprehend an immediate battery. The defendant must have intended either to commit a battery or to make Krista Noel Calloway reasonably fear an immediate battery. An assault cannot happen by accident. At the time of the assault, the defendant must have had the ability to commit the battery, or must have appeared to have the ability, or must have thought he had the ability. Second, that at the time, Krista Noel Calloway was the defendant's spouse or had a child in common with the defendant. And an assault does not have to cause an actual injury. However, if there was an injury, you may consider the injury and the other evidence in determining whether or not there was an assault. Moving on to evidence instructions, folks, page 1. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case. When the lawyers agree on a statement of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you are not required to do so. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant has a reason to commit the alleged crime. She only has to show that the defendant actually committed the crime and he meant to do so. The defendant's intent may be proved by what he said, what he did, how he did it, or by any other facts and circumstances and evidence. Back to the submenu, going on to witness instructions, page 1. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You've heard testimony from a witness who is a police officer. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witnesses. Ms. Mandarich, satisfied with the instructions as given?
Yes, Your Honor.
And Mr. Kaplan?
Yes, Your Honor.
All right. Folks, two things. First, when Officer Kralva takes you in to deliberate, we have prepared a jury verdict form, which has been approved by the attorneys and myself. He'll take that in with you. And lastly, this is the part I hate most about any jury trial. Because I've watched you, all 7 of you have paid attention. You've been very attentive. And this is the part where I just randomly pull a number out here and kick one of you off the jury. And I hate that, but I'm doing it because that's the way we do things. So if you are the kicked off juror, and you want to stick around just to see what happens, I encourage you to stay. After every jury trial, I go back in the deliberation room and I call it my debrief. I just sit down and answer any questions I can answer about the process, about this trial specifically. Try to get some comments from you, how we could make things less uncomfortable for the next jury that comes in. And if the alternate that gets picked to not go into the deliberation room wants to go back in for that final review with me, you're welcome to do so. So if I pull your number out right now and I kick you off, feel free to stick around. Don't feel like you have to, but feel free to stick around. So what I've got is I've just got 7 little wooden beads in this box that have numbers on them, 1 through 7. And juror number 2, Mr. Martin, you are thanked and excused. And once again, feel free to stick around if you'd like. We'll let Mr. Martin clear out of the jury box, and then Officer Kralva will take you back to start your deliberations. And folks, he's there all the time you're in the room. So if you need anything, just knock on the door. He's right there. And if he has to leave for some reason, we have one of our other guys there. Thank you, Mr. Martin. You know what? You can just leave it right there on the counter. It's fine. We'll clean them all up. Thank you, sir. Appreciate your time today. So where are you guys at, the sandblast place?
Oh, Inkster Road, Redford.
Really?
Yeah.
Okay. Sandblasting and powder coating. Take them out, Joe. Oh, and I didn't say it, but take your notes now if you use them. Yeah, you can take the iPad if you want to look at the instructions. If it'll be helpful, take it with you. And we are in recess.
Thank you.
Take a break.
Sticker for tomorrow.
Nope.
I don't know where you're thinking of. I did not want to schedule those without him being present, but his, counsel, I think it's.
Oh, yeah, because someone stood in for him.
Yeah, I think it was Carrie Martin's like, nope, it's fine, he told me to schedule it. That's my only concern, and especially if he didn't comment back about that late, judge said it's fine if she comes in at like 11.
Yeah, and he was CC'd, and I like double checked, and I'm like, yeah, I CC'd the right attorney.
So, I don't know if you want to call.
I will try to give him a call. Let me pull up my docket for tomorrow. And Sona's handling the Alexander Forsyth.
I usually only say that little for the attorney.
Yeah. No, I appreciate that because well, you know how it is. They schedule us to be in 4 million places at once, and
Yeah.
I literally have nightmares about missing hearings. Because sometimes in circuit court, they schedule things without telling me, and then they call me and they're like, where are you?
Yeah. Yeah, understandable.
Yeah, I'll give defense counsel a call. And I would feel really bad for my complaining witness if she shows up and
Yeah.
misses the crash. Just from this weekend.
You went again this weekend?
We didn't win, we were the only.
I mean, you went.
Oh, yeah, we went, yes. I met a Sunday, but this is her last time in the 15 to 18 class, but came out of her brain. Tongue sticking out of her face.
To the side?
Yeah. Like, okay, at least it wasn't on the show.
Yeah. And what kind of show?
Great.
Oh, she's a great.
Yeah, I got a great one, and I got a board.
Yeah.
Oh, yeah, the warriors are just long hair. Yeah, just the Russian version. But she's got.
Oh. Yeah, they're deliberating now. Probably.
It's good. Very. Been crazy. How's everything with you?
Everybody's healthy.
That's all we can ask for right now. Thank you. I appreciate it.
Oh, let me go find it.
You gotta,
Okay, yeah, you heard that.
Yeah, you just walked through.
Yeah, he said.
You go say something to, prosecutor? Joe thinks they might be right. You
Okay.
guys just sit out there.
All right, perfect. Thanks.
So the complainant didn't stick around to see the end.
Did she not?
I don't see her out there, and she didn't come in for closing.
She was in, I think she was in an office. I don't know if she's still there.
This morning. This
Oh,
one's supposed to come down this
I'm
morning.
so happy it's cold.
I'm not, I took off my undershirt earlier and I had to go put it back on when we were sitting out here.
Ready to go. Yeah, you go.
What's the wedding?
I didn't know Joe had that good, sense of humor. Have a seat. All right, it looks like maybe Mr. Bartholomew is the foreperson. Would you give the jury, I'm assuming the jury's reached a decision because you've got paper in your hand. All right. Thank you. All right, Mr. Bartholomew, would you let the parties in on what you decided?
The jury found the defendant not guilty.
All right, and Ms. Manrich, would you like me to poll the jury?
yes, Your Honor.
All right, Mr. Bartholomew, you said it, so I'm assuming that's your decision.
Yes.
All right, Mr. Cripps, is that your decision?
That's correct.
Ms. Boyson?
Yes.
All right, Mr. Anderson? All right. And Ms. Butler, there's so many names in that seat. All right. And I'm gonna try it. I wanna see if I can get it right. In Duquay?
Oh, my. Yes.
Your decision, sir? Thank you. All right. And I don't think we have a cash bond. We don't. You're free to go. Have a nice day.
Thank you.
All right, now, if you'll take them back in the jury room, I'll be right back there.
See you guys.
Yeah, you
Always.
should.
Good to see you too.
My dockets are Thursday morning, so I can't do the Thursday dockets with you guys. And I'm in Oak Park then.
How's it going?
It's a mess in that court.
Where at?
Oak Park.
Good luck.
Oh, I'm sorry, Judge. Are we? Oh, sorry, I didn't realize you ducked away. Are we allowed to ask the jury questions about?
Yeah, you know what? I'll tell them, I make them stay for me. I don't make them stay for you. But I'll tell them that, if they want to stick around,
Okay,
you might have some questions for them, or they might have some questions for you.
yeah,
All right, I'll let you know.
thank you.
Thanks.
Yeah.
2:30?
That's one of the juries.
2:30.
So, she didn't know she should get off.
What is that tomorrow? Or is it always she can't?